Did you know that there is more than one way to get divorced in the state of Connecticut? Well, there is. Hi, I'm Kristen Wolf with Wolf & Shore Law Group, and I'm going to sit here today and explain to you the differences between these three types of divorce. So before we begin, I want to strongly recommend that if you're going through a divorce, you get an attorney, and an attorney that you trust. We tell people all the time that sure, you can do it on your own. However, if you make a mistake, it is much harder for us to come in and fix it than it would be for us to get it done the right way. So if you're looking for a divorce attorney, please go visit our website at www.wolfandshorelaw.com. There are three ways of getting a divorce in Connecticut: litigation, mediation, and collaborative divorce. So let's talk about what way would be best for you. First, let's start with litigation. Litigation is what we consider to be the traditional way of getting a divorce. You file papers in the court, and the court monitors your progress as to how quickly your case is moving along and can provide some court intervention if it's necessary. We usually recommend that parties who either can't agree, are kind of at each other's throats, or simply just need the assistance of the court to push things along and to make sure that they're staying on track. Litigation is oftentimes considered to be a more contentious route, but it doesn't have to be. Remember, negotiation is a huge part of litigation. You can always negotiate in any way that you get divorced, so long as you have the right attorney to do so. When using litigation, you can get interim orders such as child support and alimony prior to your divorce being done. So if you think that you and your spouse are either not going to be able to reach an agreement, or you're going to need the court to enter some intermediate orders prior to the end of your dissolution, litigation is probably the way for you to go. The next type of divorce is collaborative divorce. A collaborative divorce consists of having two attorneys who are certified in collaborative divorce, as well as a financial neutral who is also certified, and sometimes a mental health professional or a parenting coach. All of the professionals and the parties going through divorce come together, either physically or virtually, and try to resolve the issues that are presenting through the divorce collaboratively. The benefits of collaborative divorce are that you are surrounded by a team of professionals that are trained and certified in how to help parties in a divorce reach a resolution amicably. Additionally, you're only hiring one financial professional and one parenting coach, as opposed to having two separate ones on two different payrolls coming in and going into court. So if you think that this is something that would benefit you, collaborative divorce is probably the way to go. There are some downsides to collaborative divorce, however. If you're going through collaborative divorce, you need to have an attorney. Additionally, you're not going to get any interim orders, so to speak, because the court will not be involved until the very end. If you don't think that you can reach an agreement and you will need to have some interim orders, collaborative divorce may not be right for you. And lastly, we have mediation. Mediation is typically best for people who have reached an agreement as to the main issues in a divorce and really just need to have the assistance of a neutral professional to help them get over the hump of the last several issues that are outstanding. Mediation is really great for people who get along, for people who are capable of coming to an agreement with their soon-to-be ex, and for people who are not looking to go into the courtroom. Generally speaking, mediation is done faster than a traditional litigation divorce, and it offers a safe place for both parties to air out their grievances and to put their position on record with one another. The downsides to mediation are that, number one, if either party digs their heels in and an agreement cannot be reached, well, then you've wasted a lot of time and probably a lot of money getting to this point, because you're going to have to start over. The other downside is that, remember, a mediator is a neutral third party. That mediator does not represent either of you, and therefore they are not looking to see whether or not an agreement is fair and equitable for both of you. They are really just there to help you reach an agreement. You may have to retain review counsel for both of you to review the agreement and to ensure that your rights are protected under that mediated agreement. So if you and your spouse are on speaking terms and you think that you are capable of reaching an agreement together without the assistance of the court, then mediation might be right for you. I know this is a lot of information and it can be really confusing. However, at Wolf & Shore, we are not only licensed to practice law, but I am certified in collaborative divorce, and both Sherry and I are certified mediators. If you have any questions about divorce or custody or any other family law issue, check out our website at www.wolfandshorelaw.com or give our office a call, and in less than an hour, we will outline the process for you and give you a strategy and tips and tools as to how you can be successful. We understand that going through divorce is highly emotional for you, but it's not for us. We know exactly what it takes and we'll give it to you straight, and we will never sugarcoat it for you. Besides, have you ever argued with a woman before? I'm Kristen Wolf with Wolf & Shore Law Group. Thanks for tuning in, and we'll see you next time.